Good morning, everyone, and welcome to our webinar on all things holiday. I'm pleased to be joined by my colleagues Lee and Fiona to take you through the rollercoaster ride of law in relation to holiday over the last 20 years. It's going to be an emotional journey, so buckle up and prepare for some ups and downs. Tom, can we have the next slide, please? Okay, so I'm going to take you back to 1998, which were, of course, simpler times. You could leave your front door open. There was no social media. There was no need to remember 75 different passwords. Much simpler times. And the situation in relation to holiday was envisaged fairly simple. Holiday entitlement under the working time regulations, it's important to remember, derive from the EU Working Time Directive, which was implemented by the UK in 1998. And the EU Working Time Directive was primarily a piece of health and safety legislation. It was about ensuring workers were safe at work by not being overworked. So introducing things like the 48-hour week, entitlement to rest breaks, and entitlement to 4 weeks paid annual leave. It was never envisaged, I don't think, that it would cause so much confusion and so much litigation around entitlement to holiday. And there are two fairly basic concepts. First is entitlement to 4 weeks paid holiday. And the second, the UK said that holiday would be paid at the rate of a week's pay. And we had, within the Employment Rights Act 1996, a ready-made definition of what constituted a week's pay, because that was the definition that was used for things like calculating redundancy pay and notice pay. So straightforward, 4 weeks holiday paid at the rate of a week's pay. In 2008, after some lobbying by trade unions, the EU minimum 4 weeks under UK law became 5.6 weeks, because it was felt that 4 weeks was a bit mean and was lower than the general minimum holiday that was given to workers, which tended to be 20 days for a full-time worker plus 8 bank holidays, which is 5.6 weeks for a full-time. So there was an additional 1.6 weeks granted under UK law in 2008. The reason why I mention that, and the reason why that's important, is because a lot of the case law in this area derives from the European directive and what the European directive means for workers. And therefore, a lot of the law and the case law applies rules to that EU 4 weeks, which is different to the additional UK 1.6 weeks. So at various times today, either I or Lee or Fiona will talk about the 4 week entitlement as opposed to the additional 1.6 weeks. So setting the groundwork, just wanted to be clear on that. So that was how we started in 1998 and carried merrily on for a number of years. Next slide, please. Then in 2014, we had a series of cases leading up to this, but the main headline-grabbing case was the case of Bear Scotland. This was a very exciting time for employment lawyers. I remember driving home from work, listening to the 6 o'clock news, and employment law was the lead item on the 6 o'clock news on the radio. So very exciting time for employment lawyers. And the reason it was the lead item on the 6 o'clock news was a very significant decision about what constituted a week's pay under the working time regulations. Since 1998, employers have been merrily using the calculation set out in the Employment Rights Act, exactly the same calculation as for redundancy pay. We then had a series of European cases that said our interpretation of the EU directive is that holiday pay should reflect normal remuneration, which in layman's terms was, if someone takes holiday, they should receive what they would have earned during that week had they been at work, broadly speaking. And there was a concern that the definition used in the UK legislation, that of a week's pay under the Employment Rights Act 1996, didn't comply with this because, for example, it just paid you if you work normal working hours, whatever your entitlement under your contract was to your 35-hour week or your 40-hour week, and it didn't factor in things like overtime, commission, allowances, etc. And the best Scotland case was the leading case in the UK that said, essentially, the UK legislation is wrong. It doesn't comply with the EU legislation, and we need to read it and interpret it in a way such that it does comply with EU legislation, and that therefore there are a number of things that employers, you haven't, perfectly innocently and perfectly naturally, been including in your calculations of holiday pay that you ought to have done. And there are some examples given on this slide. So the first example given that arguably should always have been included was that of guaranteed overtime. So if someone works 35 hours a week, but you are guaranteed 3 hours overtime, paid at double time, that should be factored into your holiday pay calculation. The second issue that was dealt with, and the second concept, was that of non-guaranteed overtime, which was the specific issue in the Bear Scotland case. So that was where you weren't guaranteed overtime, but if your employer required you to work overtime, you had to do it. So it wasn't compulsory, but if the employer says, right, we need extra hours on Thursday night this week, under your contract, you can be required to work overtime, so I'm requiring you to, that was something that ought to be factored into the holiday pay calculation. The Bear Scotland case left open for debate the issue of voluntary overtime. Example being, we're doing a stock take this weekend. Does anyone fancy doing overtime, coming in 9 o'clock on Saturday till 5 o'clock on Saturday? Or a rota that you could volunteer to be on. That was left open, but then a case involving Dudley Metropolitan Borough Council confirmed that provided voluntary overtime was worked sufficiently regularly, that ought to be included in holiday pay calculations. There's no statutory definition of what constitutes sufficiently regular, but in that case, working the overtime once every 4 or 5 weeks was deemed to be sufficiently regular. Allowances, so some travel or antisocial hours allowances, also are a case of saying they ought to be included in holiday pay calculations. I say some travel allowances because there's a distinct those that simply compensate for expenses. So expenses claims and expenses don't count as part of your week's pay, but travel allowances, radius allowances, antisocial hours allowances, if they are generally what you receive for doing your work, they ought to be included in your holiday pay calculations. Another controversial element was that of commission. And in the British Gas and Lot case, they confirmed that regular commission type payments ought to be included in holiday pay calculations, because the principle was, if you take a week's holiday, not only do you miss out on your wage for that week, your salary for that week, but you also miss out on the opportunity of generating commission. And on the principle that you should earn what you would have earned had you been at work for that week, you ought to include commission. That was even the case in the British Gas case. I think British Gas even argued that, well, look, we've already factored into our commission scheme the fact that people will only be working 48 weeks of the year. So it's factored into the generosity of the commission scheme. But the court said that that wasn't a sufficiently strong argument. They still needed to work out their average holiday pay, factoring in the commission that would have been earned during that time of holiday. And the final example that I'll give are things like standby and on-call payments. Again, regularly earned, if they're part of an employee's normal remuneration, these things should be factored into holiday pay. So This was very bad news for employers. On our roller coaster, we're right at the bottom, because suddenly there were loads of payments that employers hadn't been factoring into holiday pay that they suddenly became liable for. And that meant employers being challenged to make changes moving forward and calculate holiday pay correctly moving forward, and potential liability for claims for back pay for underpaid holiday in respect of historic periods. So bad news for employers, but not all bad news. If we move to the next slide, please. There are a number of ways in which the impact of this was mitigated by both the government and by the employment tribunals. So the first mitigation is that this law, as I mentioned at the outset, applies only to the EU 4 weeks. So in theory, it doesn't apply to the additional 1.6 weeks granted by the UK in 2008. And it doesn't apply to any additional contractual holiday beyond the 5.6 weeks. Some employers are more generous than the 5.6 weeks, or 28 days for a full-timer. So in theory, that was a mitigating factor. In practice, a number of employers we advised at the time said, well, look, it's very difficult for us to be saying to employees, well, we're going to factor in overtime for your 4 weeks holiday, but not for your 1.6 weeks. So there were perhaps mixed messages there, but in theory, that was one mitigating factor. The second mitigating factor is, whilst it took a while, at the time of the Bear Scotland case, the reference period for calculating holiday pay was 12 weeks. That has now changed to 52 weeks. And that, again, mitigates the consequences, because it smooths the curve, as it were, in the sense that there were concerns that on the basis of the law as Bear Scotland had it, when you just had to look back for the last 12 weeks, if you were a savvy employee and you had seasonal peaks and troughs, let's say leading up to Christmas, what you would do is you'd work loads of overtime in the 3 months leading up to Christmas, then take 2 weeks holiday after Christmas, and that 2 weeks holiday would be based on your average pay in the previous 12 weeks, which wasn't really representative of your annual average pay. So you got a bonus depending when you took your holiday. So there was an incentive to take holiday at certain times and a disincentive to take it at quiet times of the year. That curve has now been smoothed for employers. The other good news for employers is that following these revelations in 2014, the government stepped in and effectively put a 2-year limit on claims for back pay, because they recognised that, or two things, I think. One, if there are claims for historic back pay going back to 1998, that's going to cost the UK economy a hell of a lot of money. And two, it might lead to claims from employers against the UK government for their incorrect implementation of EU law, because it was only the government's legislation, if you like, and the wording of that legislation that led employers to pay holiday pay the way they had been doing. So the government stepped in fairly quickly, and in July 2015, they capped those claims at 2 years back pay. The final mitigation was the judges in Bear Scotland, and you got to remember this was before there was the 2-year cap on claims for back pay. So they were contemplating potential claims going back to 1998 for some workers. Is the decision in Bear Scotland said, well, claims for holiday pay are claims for unlawful deduction from wages. A claim for unlawful deduction from wages has to be made within 3 months of the unlawful deduction, or within the last in a series of unlawful deductions. So if your pay is short every month, you can claim going back to however long until your pay was correct. But what they said is, because of that 3-month time limit, they said, therefore, if there is a 3-month gap between unlawful deductions, you can't go back beyond that gap. that 3-month gap breaks the chain. And this was something we'd not heard of before. It was difficult to see, or not difficult. It is quite difficult to see how they get that from the legislation in the previous case law, but nevertheless, they say there's this 3-month gap, and that breaks the series of deductions. And that significantly mitigated the exposure of employers, because bearing in mind that this case law only applies to the EU 4 weeks of holiday, what they'd say is there is quite often, if employees and workers look back over the last 2 years, quite often you can find a 3-month period when either the employee didn't take holiday, so there were no unlawful deductions, or the holiday they took was not part of their EU 4 weeks, but was part of their UK 1.6 weeks, or their additional contractual holiday, and was therefore not. There were no unlawful deductions. Therefore, you got this 3-month gap. Therefore, you need not go. So, having had disaster on our minds in 2014, we've seen plenty of claims, but we've not seen the avalanche of claims that perhaps we might have seen had everyone been entitled to claim back to 1998, and had we not had this point about the 3-month gap. So employers are looking a bit more optimistically at the issue. It's been a pain, but it's been a manageable pain. However, next slide, please. It could get worse. It could get worse. It's not all good news. So there was a case in the Northern Ireland Northern Ireland Court of Appeal, in which the Northern Ireland Court of Appeal said, we don't agree with this point about the 3-month gap. Doesn't make sense to us. And we don't agree with two things. One, we don't agree that automatically workers are deemed to take their EU 4 weeks holiday first and then their 1.6 weeks, which helps to generate this gap. And two, we can't see in the legislation where on unlawful deductions, we can't see how you can interpret that as meaning if you bring a claim from within 3 months of the last of a series of deductions, any gap of 3 months during that series causes a break. We don't see that. We don't believe that. That case was heard in the Supreme Court in December last year, and a decision is expected soon. If this decision approves the decision of the Court of Appeal in Northern Ireland and gets rid of that point about the 3-month gap in unlawful deductions, it could have a significant impact. Claims for employees who have been paid holiday pay can still only go back 2 years, but instead of, as they have been doing, going back 3 months, they could go back even further to the full 2 years. In Northern Ireland, they don't have the 2-year cap on unlawful deductions claims. So in that case, the police service of Northern Ireland, bearing in mind this case has 4,000 employees, 4,000 claimants, say at the moment their liability is £300,000. If the case goes against them, the liability is £30 million in terms of all that back pay. So a really significant case. Could get worse for them, but as I say, could have an impact on claims in respect of and the exposure in respect of claims in England, Scotland and Wales. So that's the roller coaster ride so far. A link that I think the One Show would be proud of here, from roller coaster to rolled up holiday pay. So I'll pass over to Lee at this point.
Assuming that I can keep talking over the groan that I've just let out from that awful link. Thanks, Matt. So I too am going to take you on a roller coaster ride. Mine's also going to be a history lesson as well. I'm going to take you back to simpler times in the way that Matt started out this morning. I'm going to go all the way back to the late 1990s to begin with. And the reason I'm going to do that is because I'm going to end up in the present day, and I'm going to end up with the Supreme Court case that we all heard about last year, the case of Brazel and Harpur Trust. But to understand that case, as I say, I'm going to go right the way back to the late 1990s. And I'm going to go back to the introduction of the working time regulations, which, as we all know, brought about the entitlement to paid holiday for people in the UK. And that came from a European directive. And it's worth noting at the time that the UK at the time had the ability to veto various laws coming out of Europe, but could only do so in certain categories. And John Major was against the introduction of paid holiday for one reason or another. And Europe got round that by saying, well, it's not an economic matter, it's a health and safety matter. It's vital that workers have a break or breaks during the year in order that they can recharge their batteries and recuperate. And so that when they're back in work, it's safe for them to be in the workplace. And if you think about that in terms of operating heavy machinery in a factory, then you get the gist. So 1998, the right to paid holiday is introduced. A lot of people had paid holiday in the UK before that. Where it really sort of took effect was people who were casual workers, low paid workers, people who were paid hourly rates of pay rather than receiving annual salaries. And so cunning employment lawyers, my predecessors and Matt's predecessors, because we're not as old as we look, decided that actually, well, they'd already been paying holiday pay. They actually had just rolled it up into the pay that they were already giving their workers. And so they didn't need to give them paid holiday. Or alternatively, what they started to do was just add a bit on to each hourly rate of pay to account for holiday pay when someone took the holiday pay. And it became known as rolled up holiday pay. Then other employment lawyers got involved and they started to argue on behalf of the workers. And they said, well, no, you can't roll up holiday pay because that deters people from actually taking holiday, because at the time they're taking holiday, they're receiving no pay at all. And that was a similar argument that was run 20 odd years or 30 odd years later by Mr. Locke about his commission with British Gas, was that if I'm not paid all I should be paid when I'm on holiday, I'm deterred from taking it in the first place. And the reason I should be taking it in the first place is so that I'm safe in the workplace. That's what Europe told us. And that's what Europe told John Major back in the late 1990s. Things came to a head in 2006 with the Robinson-Steele and PD Retail Services case. And that swept up a number of other cases that were arguing the same thing. And first up to have a say on that, right at the top of the employment law tree, if you like, in the UK, was the UK's Advocate General, the most senior lawyer, who said, well, it seems to me that it's sensible to have rolled up holiday pay if it's transparent, if it involves an addition to basic pay, and there are adequate arrangements made to make sure that the worker in question takes the holiday to which they're entitled. Fine, there you go, problem solved. But theirs wasn't the ultimate voice. That fell to the European Courts of Justice. And they said, no. Rolled up holiday pay is unlawful. It's contrary to the law that we set down in Europe, the Working Time Directive, and on which our working time regulations are based. And because rolled up holiday pay means that when workers are taking holiday, they're not actually being paid for the holiday they're taking. They've been paid some additional money in advance, and they weren't happy about that. However, if we go on to the next slide, there was some better news for everyone. Whilst it's unlawful, the good news is that and we know this, I mean, we know now, don't we, that rolled up holiday pay is still being used in the UK now. There are people today receiving their pay packets and they've got rolled up holiday pay in it. And the reason for that is the employment tribunals will, if you end up there having a rolled up holiday pay argument, will take into account rolled up holiday pay when they're calculating someone's holiday pay, and they'll offset it. And they'll do that if it's very clearly marked on the pay slip that it's holiday pay in addition to their basic rate of hourly pay, and that person's been given the opportunity to take their holiday, then they'll get set off. So it's not all doom and gloom. And I've got to say at this point that I've never faced a case, and I've been an employment lawyer now for about 15, 16 odd years. I've never faced a case where someone has claimed that their rolled up holiday pay was short, because people generally quite like it. It's a simple solution to what they need. And that comes from both workers and companies alike. There are risks involved with rolled up holiday pay, so it's not quite all as sun as it might seem. There's a danger that there's a claim available to people that their compensation for not being able to take holiday is deemed by the law as being just and equitable. So should they be receiving some compensation for that? And also, you're always running the risk that if you find yourself in the employment tribunal, that they take a very, very restrictive interpretation of the set-off, that they don't really give you as much credit as you were hoping to receive from your rolled up holiday pay. But as I've said, I've never seen a claim yet. Colleagues have, but I've never seen one. So you'd be thinking, wouldn't you, that it's quite easy. And if you've got staff that you're rolling up holiday pay on, well, then you need to know, of course, how much are you going to pay them? And so we'll look at that on the next slide. It's easy. We all know what rolled up holiday pay is. It's 12.07%. It trips off the tongue. What could be easier? And the reason I brought this up, because it's helpful to understand how you get to that number with rolled up holiday pay, because again, this takes us one step closer to the Brazel and Harpur Trust case. The reason you get to that number is this. Everyone's entitled to 5.6 weeks holiday, and that's a point I'll come back to as well when we talk about Brazel. And so in 52 weeks of a year, there are 46.4 weeks when you're working, and there are 5.6 weeks when you're on holiday. 5.6 weeks over 46.4 weeks, and you'll all be doing the maths in your head, is absolutely right, is 12.07%. 5.6 weeks is 12.07% of your working weeks of the year. And so you add 12.07% to everyone's pay, and what you end up doing is when you total up all those separate 12.07% from all those pay slips, that equals 5.6 weeks holiday pay over the course of a year. That's how you get there. Simple. If your maths isn't as good as mine, I pity you. If your maths is better than me, hopefully you followed that as well. But there you go. I'm a lawyer. I'm certainly not an accountant, but you'll just have to trust me on that. So it's easy. There you go. Rolled up holiday pay, not a problem at all. Next slide. Hold on a minute. It's not that easy. We've had the case of Harpur and Harpur Trust and Brazel last year, which got to the Supreme Court. And I think it's fair to say for a few weeks sent the world, or the HR world and the employment law world, into a meltdown. And it's caused a bit of a stink. And it's caused a bit of a stink because 12.07% as rolled up holiday pay works across a 52-week year if someone is working 46.4 weeks in that year and taking the rest of the year as holiday. But people, for example, who only work in term times, school term times, only work about 36 weeks in a year. So 5.6 weeks is a bigger proportion of 36 weeks than it is of 46.4 weeks. And here we find ourselves with the case of Mrs. Brazel and Harpur Trust. Harpur Trust is the organisation that runs Bedford's Girls' School. Mrs. Brazel is a saxophone and clarinet teacher, a very good one by all accounts, and she comes into the school during term times to teach pupils on an individual basis, probably at lunch times and so on, either how to learn the clarinet or the saxophone or how to get considerably better at it. She has a 0 hours contract and she's paid by the hour by the school. Some weeks she wouldn't work at all, others she'd work quite a bit, but she never worked outside of term time during school holidays. And she started work there in 2002, and up until 2011, everything was hunky-dory. Everything was absolutely fine. The school gave her 5.6 weeks holiday a year. She was deemed to take that in 3 equal blocks of, a bit more maths, 1.87 weeks each holiday time. So at Easter, Christmas, and in the summer holidays, the school would pay her 1.87 weeks of holiday pay, and they would calculate it in the way that Matt's been talking about, and they would calculate it as a week's pay for each one of those 1.87 weeks of holiday. So 1.87 of her normal weekly pay. Fine. For reasons I don't understand and have never been able to find in any of the reports I've read or any of the judgments I've read, the school changed that in 2011, and that's what triggered the claim. The school took it upon themselves, and I think understandably, to say, well, hold on a minute, you shouldn't be getting 5.6 weeks holiday because you don't work a whole year, Mrs. Brazel. You only work about 36 weeks in a year, so it should be prorated. And at the same time, it started using holiday pay, rolled up holiday pay. So it started applying to the 12.07% rolled up holiday pay. Going from there, what that meant was Mrs. Brazel saw a drop in her holiday pay, which she was still being paid each main holiday, each Christmas, Easter and school and summer holiday. She saw a drop of about 50%. What a brilliant way to promote, to push someone into bringing an employment tribunal claim, to cut their holiday pay by 50%. And off we went. And the claim unfolded over about 5 or 6 years, maybe longer, and ended up in the Supreme Court last year. And what did the Supreme Court say? Well, the Supreme Court said, well, no, hold on a minute. Everyone who is employed for 52 weeks of a year gets 5.6 weeks holiday. It doesn't matter how many weeks in that year they work. Point number one. And point number two was they said, in this instance, as always, as we've said before, rolled up holiday pay is unlawful. Well, what does that mean? What it means is, as we'll see from the next slide, is that it creates an anomaly for people. So if we look on the next slide at the exam invigilator, for example, and this was a point that the Supreme Court even raised in its judgment. And this is why everyone got themselves into a bit of a spin about it. Take the exam invigilator. At the end of each term, the exam invigilator comes to school and works for 1 week invigilating exams, so walking up and down, looking at people's desks, making sure they're not cheating. Does that 3 times a year for 1 week. They do it for 40 hours in that week, and there you are. But even though they've only worked 3 weeks in that year, they've been employed for an entire year, so they get 5.6 weeks holiday. And when you calculate their 5.6 weeks holiday pay, they get a week's pay for each week of that 5.6 weeks holiday. So you will pay them to work for 3 weeks. You'll then pay them the same amount each time for those weeks for 5.6 weeks. You end up paying them for 8.6 weeks full pay, if you like, even though they've only worked for 3 weeks. Bonkers. Absolutely bonkers, a lot of people would say. I'm not going to say one way or the other. I'm an employment lawyer. But there you go. That was the anomaly it threw up. And it threw that anomaly up with Mrs. Brazel herself. Her rolled up holiday pay should have been around about 17.5%, but it was being calculated at 12.07%. And that's an issue. But it's only an issue, it's worth pointing out, if you've got people who aren't working a full year, who aren't working week in, week out. It's casual workers who don't work every week, or term time workers. This doesn't affect, and a lot of people missed this last year, this doesn't affect people who work full-time. It doesn't affect people who are part-time workers who work every week in the year, apart from when they're on holiday. And it doesn't even affect term time workers if they're receiving an annual salary, because if you're receiving an annual salary that's paid in 12 equal monthly installments, you're paid the same each month anyway. Your pay isn't fluctuating in a way that changes the calculation. So perhaps it's not quite so bad as it seems. And if we look at the next slide, we can look at how people are dealing with it. Well, what does it mean? Well, some people are looking at how they're employing people, because with an exam invigilator, do you need that exam invigilator for an entire year if they're only working 3 very distinct assignments of 1 week during each year? So some people are reviewing their contracts and actually having each standalone assignment being their specific periods of employment. And so they're only accruing holiday for that 1 week in which they're working, because in effect, they're ending their employment each time at the end of 1 week's invigilating, waiting the 13 or so weeks and employing them again for another week. So they're getting around Brazel like that. Some people are moving away from the 12.07% calculation and are trying to work out better calculations for term time workers. As I said, for Mrs. Brazel, in her instance, it calculates at about 17.5%. Something for you to mull over if you finished your Sudoku at lunchtime as to how you get to that number. Other people are complying with Brazel. And so they're going back to what we know, which is that everyone gets 5.6 weeks and everyone's holiday pay is calculated, assuming their pay fluctuates, against the 52-week average. And you go back each week counting 52 weeks in which they've worked to take their pay. If there's a week in which they've not worked, you keep going, you discount that week, you jump past it and keep going back up to 104 weeks. If someone's not worked more 52 weeks and 104 weeks, you take the number of weeks in which they have work and divide it by that number, Hence, the invigilator who only works 3 weeks in a year gets their week's pay, total week's pay, divided by 3 to get to the average. Others, and I have to say, I think the majority have stuck their head in the sand about this and haven't changed things at all. And often, if you'll speak to me, I will say to you, why change things if things seem okay? If people aren't complaining, why make a change? You're doing it for a cultural or a moral reason. You're not doing it potentially to mitigate a risk, because at the moment there is no threat of a claim against you. So there you go. So perhaps it's not quite so bad. And if we look at the next slide, potentially things are going to get better. You can say what you like about the government from the last 3 or 4 years, and there's lots being said about it all the time, but they've absolutely swept in on the back of the Supreme Court case, so the Brazel case, to pick up on this anomaly and to make life potentially better. So they launched a consultation in January of this year. They ended it just about 2 weeks ago on the 9th of March, because they recognised that there were these anomalies. The exam invigilator, the Mrs. Brazels of the word, created an anomaly, and potentially in some people's lives were receiving too much holiday pay and potentially receiving too much holiday as well. And so the consultation was based around, well, is that right? Should the amount of holiday you receive be proportionate to the actual time you spend working in the year, rather than simply the fact that you are employed for a year? And if that's the case, then, well, can't you just fall back on our old friend, 12.07%, to calculate what people's holiday entitlements should be against the hours they've worked, and similarly, then the pay they receive as well? So we'll have to wait and see. I don't know if this is going to make the news and make Matt's ears prick up on his way home. We'll have to wait and see. That's my roller coaster. I don't have a terrible segue because Matt didn't tell me that I was going to need one. So I'm just going to hand over to Fiona now to take you through the last part of the session.
Thanks, Lee. So I'm now going to turn to holiday pay and sickness. Again, another area where it has been uncertain. And we had a string of cases coming through, the most well-known one being Stringer, which I'm sure you'll all recall. And that was Stringer and HM Revenue and Customs. And that was a European case. And it confirmed that when you're on holiday, you continue to accrue sick. Sorry, the other way around. I'm just getting a bit of feedback. Sorry, can you hear me okay? Yeah, okay. So in the Stringer case, the ECJ held that you accrue annual leave whilst you're on sick. It was for member states to decide whether a worker could take their annual leave during a period of sick. And at the end of a leave year, a worker who has been on sick leave, who's been prevented from taking annual leave, must be allowed to carry it over if they're prevented from taking it. And finally, that the right to be paid in lieu of accrued holiday on termination applies whether on sick leave for the whole or part of a year. Now, the Stringer case was then considered by the House of Lords to consider it in line with the working time regulations in light of the ECJ ruling, and the House of Lords held that yes, statutory holiday entitlement under the working time regulations accrues during periods of sick. Payments in lieu of statutory holiday on termination are unaffected by sickness absence, and that the working time regulation should be interpreted as allowing workers to take paid statutory holiday during periods of long-term sick. So that set out the position. We then had the Pareda versus Madrid case, which looked at what happens when prearranged holiday coincides with sick leave. And the Pareda case said where that situation arises, the worker has to have the option of being able to take the annual leave at an alternative time, even if that falls after the end of the relevant leave year. And that would be contrary to the working time regulations. Now, in the Pareda case, the individual concerned was sick before they went off on holiday, but there was then a subsequent European decision which looked at what would happen if you were sick during your holiday, and it said the same principles apply. So if an individual is sick before their holiday or during their holiday, the same principle applies, and they should be allowed to take their leave at an alternative time. There were also some cases looking at, well, if you can carry over your leave because you've not been able to take it because you've been sick, is there a limit on the length of time an employee on long-term sick can continue to carry over the untaken holiday? Because you might have a situation where somebody's been off for a long period of time. When does that end? And there was the case of KHS AG versus Schultz, where that involved a worker who had been off for 6.5 years, and he claimed pay in lieu of several years and taken holiday on termination. Now, the relevant collective agreement said that all holiday not taken within 15 months of the end of the relevant year would be lost. And the ECJ again agreed with that and held that that limit did not infringe the directive. And there's been a subsequent case, Plum and Duncan Print Group Limited, in which the EAT followed the Schultz case and said leave can be carried over for a period of 18 months from the end of the leave year, and that should be read into the working time regulations. So that's the current position. So if you're faced with rescheduling holiday because an employee says they've been affected by sickness, what should you do? I think on the basis of the Parader case, it's likely that they're entitled to reschedule at least that 4 weeks leave contained within the working time regulation. Now, workers in Great Britain aren't necessarily entitled to enforce the rights set out in the directive. However, the courts and the tribunals are obliged to interpret the working time regulations in light of the ECJ's decisions. So we've certainly seen that the courts have interpreted the working time regs in line with the decisions so far. It also begs the question, if you're dealing with this kind of situation, well, what is sickness if you have this situation arise? The Plum and Duncan Print Group Limited case made it clear that they're not required to demonstrate that they're physically unable to take annual leave by reason of their sickness. So, for example, if you have somebody who goes off skiing, they've sprained their ankle, yes, okay, they're not able to enjoy the rest of their holiday skiing, but they would be fit to work. So how would you deal with that scenario? Is it the case that if they're still fit to work, do we have to reschedule their holiday? I suppose we do have to be mindful of the comments within the Stringer case, and I suppose it goes back to Lee's point about health and safety, but also about having a break. The Stringer case said the purpose of annual leave is to enable the worker to rest and enjoy a period of relaxation and leisure. And it could be argued that even though that person could work, their ability to rest and relax, has been affected. So there are arguments in relation to that. In terms of the options for employers, when you're faced with this situation, I think the most cautious approach would be to reinstate the workers' holiday entitlement. So if they've either sick before going on holiday or sick during holiday, reinstate that 4-week period. Well, obviously it'll be a shorter period, but particularly if it relates to that 4 weeks, the cautious approach would be to allow them to reschedule it. However, I think you communicate with the employee at an early stage. It might be that the employee wants to take it as annual leave. If they're down to statutory sick pay, it might be that they don't necessarily want to be recorded as sick. If you refuse to allow the worker to reschedule it, it might be that you're concerned that perhaps it's not a genuine absence. You've had somebody return from holiday saying that they were sick whilst they were off, and you doubt the genuineness of that. You could argue that you don't believe the working time regs require you to do so. However, I think following the cases and the fact that the tribunals are interpreting the working time regs in line with the ECJ cases that I've just talked about, it is likely that if you adopt that approach, it could be in breach of the working time regs. And I think in terms of the abuse point, and is this open to abuse, that is a concern of employers. I don't think we necessarily see much abuse in practice, and there are some strategies to prevent abuse. For example, as I've mentioned, if somebody is going to be on statutory sick pay, then it's not necessarily an attractive option for them to be recorded as sick. And then you've got to think about your other strategies that you use to prevent abuse in these situations. So, ensuring that they have to report sickness to their manager on the first day, requiring medical evidence, holding return to work interviews, which we know can prove a deterrent in other circumstances, monitoring and recording absences, and also making it clear that any abuse can lead up to disciplinary action. An employer could also state that they're only going to pay contractual sick pay if the worker would be unfit to do their job, which prevents that debate that I talked about earlier. If you're on a skiing holiday and you get a sprained ankle, but yes, you can't enjoy your holiday, but you could do your work, you could do your job if you're an office-based employee, for example. So there are strategies behind that. So that is a summary of holiday pay and sickness. If we go on to the next slide. So bank holidays. I just want to touch upon bank holidays, particularly the extra bank holidays, because we received lots of queries last year. Obviously, there was an extra bank holiday scheduled for the Queen's funeral. We've got additional bank holidays this year. And Matt touched on this at the very start, but when we go back to the increase in annual leave from 4 weeks, or the statutory annual leave entitlement from 4 weeks to 5.6 weeks, that increase took into account there was no entitlement to public holidays under the working time regulations. So many employers were counting those 8-day public holidays within the 4-week annual leave entitlement. So that takes into account your public holidays. Despite that, there's no statutory right to time off for bank holidays or days off in lieu on public holidays. Ultimately, you've got to look at whether it falls within the holiday entitlement under the working time regulations, so that 28 days. So in light of that, I think the starting point in relation to extra bank holidays is to look at what your contract says. So we've got some examples set out on the slides here. If it says 28 days holiday, including bank holidays, arguably there's no need to offer extra bank holidays. If you've got 20 days holiday plus bank holidays, you probably need to offer an extra bank holiday. 20 days plus the usual bank holidays in England and Wales, probably not, because it wouldn't fall within the usual that we tend to see, the 8 usual bank holidays. And then 28 days holiday, I think, is unclear and could be debated. Your starting point is, of course, to look at your contract, but then following that, I think you've got to look at, your business, your values, your reputation, consistency, in terms of, clearly last year with the funeral, the government didn't tell employers to, but they certainly suggested that employers may look to consider allowing employees to have the day off. If you didn't necessarily allow it, and it was at your discretion depending upon your contractual position, you've also got to look at the employee engagement side of things and how it would be perceived, because employees may not be happy if they weren't necessarily. Are you being consistent with what you've done in the past as well? So there's the legal position by looking at your contract, and then there's also those other issues that you need to consider that may well impact on it. So that's bank holidays. And then finally, we're just going to touch on industrial action, which seems very apt. So if we could just go on to the next slide, please. We're just going to have a look at holidays and industrial action. Obviously, we're in the midst of several strikes at the minute, with teachers, civil servants and the junior doctors strike. And employers may well be looking at, prior to obviously this week, well, how do I have the relevant cover? If someone is on annual leave, can I cancel it so that I've got adequate cover? So we thought it would be useful to touch upon that in light of the current climate. So if you wish to refuse a holiday request, obviously there's no obligation on an employer to grant a holiday request. You do have to be mindful that, of course, we shouldn't prevent the worker from taking their holiday in the leave year. So it might be that if somebody, asked for those holiday dates, we would refuse them at the outset. It might be that we want to rescind annual leave to cover any shortfall in services because of industrial action. Now, bear in mind that if we do have to rescind an annual leave, we need to provide adequate notice, and that notice must be at least the same number of days as the leave that's been booked. So do bear that in mind. And as I say, remember, we've still got to allow the worker the opportunity to take their working time directive leave up until the end of the leave year. In terms of calculating deductions of pay, obviously, if employees are striking, the employer doesn't necessarily need to pay them for the periods during which they're not working. The Cooper and others versus Isle of Wight College case looked at when you make a deduction from wages in respect of a strike day, what should be deducted? Should it be limited to the basic pay the employee would have received, or should it also include that portion of holiday that the employee would have earned by working on that day which they striked? Now, this case concerned support staff in school who were working a 37-hour week. So the debate was between whether the fraction should be 1/260, which the employees contended it should be that calculation, or whether it should be 1/228, as contended by the employer, to take into account the paid holiday and the bank holidays. And the court held that the employer could only deduct the sum equivalent to the employee's pay during the period of strike, so the 1/260, rather than the additional sum in respect of the holiday. So that is all the material we were going to cover. I'm very conscious we've got 6 minutes in terms of any questions that have come through. Shall I hand back over to you, Matt?
Yeah, thanks, Fiona. So we have had a few questions. Apologies if we don't get a chance to go through them all. First one for me, I think, is in terms of the 2-year limit on claims for unlawful deductions, does that apply to people who have never been entitled to holiday? So I think we're thinking about here about the category of workers we've seen within the gig economy, where employers have engaged them on what they thought was a contractor basis, so therefore no entitlement to holiday. They've worked merrily for 10 years, get to the end of the 10 years and say, actually, I think I was a worker. I think of the working time regulations, I should have received holiday, and I'd like 10 years worth of holiday, please. There was a case, King and Sash Windows, involving someone who worked on a commission-only basis as a double glazing sales rep, had worked, I think, for 13 years, never received any holiday, engagement terminated, brought that claim for 13 years worth of holiday, and the court said that was a legitimate claim. Ordinarily, holiday doesn't carry forward from 1 year to the next. One exception, as Fiona's outlined, is sickness. Another exception is if the employer has denied the right of the employee to take that holiday. So it wasn't that holiday was underpaid, which would have a 2-year cap. It was that it had never been paid and never been granted and never taken. So that's one that potentially has a bigger impact for those workers making claims under the gig economy. A second question we've been asked is around, both Lee and I have emphasised the health and safety nature of certainly the 20 days holiday and said that's important. Employees must be able to take their 20 days holiday. Someone out there has said, well, is there a loophole there in the sense that if you assume employees entitled to 20 days holiday, let's say they work for one employer for the first half of the year, so they accrue 10 days holiday, but they only take 5 and they're paid for the other 5. They then move to another employer for the second half of the year and they have 10 days holiday. So during that year, they've actually only taken 15 days holiday, which is contrary to the health and safety principles of the Working Time Directive, which is correct. I think the only answer to that is to say, well, the legislation sets out an exception. Generally, you can't pay in lieu of holiday, so you can't say to someone, well, you could take holiday, but instead of taking holiday, here's a payment. The only exception for that is on termination of employment. And so you will get quirky circumstances where people do move employers during the course of the year when they might not take the right amount of holiday. We also had, I think we've just got a minute for a couple of questions on holiday and sick leave. So Fiona, let me give you one of these.
I've read some of those, and I think there's 2 or 3 that we can probably roll up into one. In the sense, there's questions around if people are on long-term sick and they're not taking holiday, do they have to be given it or paid for it, and what happens at the end of their employment? So I think that the starting point is use it or lose it. So some employers during long-term sick will remind their employees that they can take their holiday while they're off sick, in the sense they can come off sick leave, particularly if they're unpaid, and then spend 5.6 weeks of the year on paid holiday pay and then go back onto sick leave again. I don't think there's any great obligation to particularly push that, but others may disagree with me on that. And then at the end of someone's employment, say for example, someone's been off sick for 4 years and you dismiss them under the grounds of ill health capability because they're no longer able to fulfill their job because of their ill health, they're broadly speaking, they're entitled to about 15 months worth of holiday going back in time, broadly speaking, or about 18 months worth of their 4 weeks European holiday pay. So I think that probably answers 2 or 3 of the questions. Matt, Fiona, you've got your eyes on them, but rolling them up together.
Okay. Well, I think that probably brings us to the end of our time anyway. I'm conscious I don't want to overrun. Following this, you will get, we've been asked the question, well, you will get a copy of the recording and a copy of the slides that we've used so that you can refer back to. You can, as Lee says, if you want to spend your lunch hour doing some rolled up holiday pay calculations, then please feel free to do that. Thank you very much for attending. We've got a couple of other webinars coming up over the course of the year, which you will have received invitations to, so it would be great for people to join us on those. But thank you very much and enjoy your next holiday.